So how do you avoid probate? So we avoid probate with a living trust. So probate's expensive, it's a hassle, it's public. Living trusts are private. They are, generally speaking, more economical than a probate proceeding, and they certainly can be wound up in sooner than 16 to 24 months. So there still is a baked-in time period there, but I would say the minimum is about 6 months. There's a 4-month waiting period in there, and we cover that in other webinars. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have 30 years experience this year. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust, and probate law, securities and insurance licensed, and a pilot. So I have a broad base of knowledge on all things estate planning and how these assets work in the living trust. We have a big group of attorneys here with us now. We are not a big firm. We are what is called a boutique firm. So we're a specialty firm. We essentially handle all things for high net worth individuals, high income individuals, dealing with trusts and trust administration and real estate and business entities. So typically centered around the mass affluent. I'm a lawyer. When I say you, there is no attorney-client relationship. This is not legal advice to you. This is very important to understand. Don't watch this. Go out and do a bunch of stuff just because you saw this on a video. Very, very important. You will want to consult with an attorney. And if you choose to use our firm, great. And if you already have an attorney, that's fine too. But please, this is for information only, maybe a little bit of entertainment. So what is a living trust? What's a living trust centered estate plan? Well, a living trust centered estate plan. So a living trust is like part of the meal. It's like the pork chop on the plate and you got vegetables and you got maybe mashed potatoes or something. That's dinner. So what we're talking about is a living trust is part of the estate. Okay, so it's part of the estate plan. There are other documents that go with it, but it's a set of documents, including a living trust, that work together, right, to provide a structure, to provide the legal authority for somebody to act on your behalf and not have to go to probate court. All right, so this is in the event of incapacity or death. So if I have a stroke and I have a bank account with just my name on it, I can't sign a check. I mean, maybe I'm unconscious, right? And I'm in a coma. I can't sign that check. Someone else is going to have to sign for me unless I have a plan in place. That person, my loved ones, are going to have to go to the probate court to get authority for someone else to sign my name. The same thing if I'm dead. If I'm dead, I'm not there to sign a check. I'm not there to sign a deed. So that's why people go to court and they get that authority to act on my estate's behalf, because there's no one living, there's no human with a heartbeat that has signature authority for the deed or the bank account. So pretty kind of Captain Obvious basic stuff. So the core documents, again, they include typically a revocable living trust and a pour-over will. Now, this will is, so you might say, well, why are we having a will if we're avoiding probate? I mean, doesn't a living trust replace that? Well, a living trust is different than a will, okay? When you have a living trust, it is still best practice to have a will that leaves everything to the trust, because too often people have assets that should be in their living trust that are not in their living trust when they pass away. Therefore, that will sort of pours that asset over. It's also called a pour-over trust, which I think is a little misleading, but it's a pour-over will. So it's this will that leaves everything to your living trust so that everything is ultimately distributed from that living trust. A trust has to be funded. So the analogy we use in our office is a trust is like a bucket. It's a bucket with a handle. The trustee's holding onto the handle. There's a bucket. That's the living trust. You put stuff into your living trust, your house, your stocks, your bonds, your mutual funds, the timeshare. I don't know about that. You might want to let that one go. I mean, we can talk about that one-on-one, I suppose. But you put all these things in your living trust bucket. You don't put your IRAs, your 401ks, your 403bs, your TSAs, your life insurance, your annuities. Those are not owned by the trust typically when you're alive. When that trustee stops being trustee and lets go of the handle, the next trustee picks the handle up. So if I have a living trust and I set up my living trust for my benefit, and then when I die, it goes to my kids, let's say, I'm trustee of that trust holding onto that handle. When I die, I let go of the handle because I'm dead, right? Someone else is going to hold onto that handle. And what that living trust says is when I stop being trustee, somebody else becomes trustee. That is the successor trustee. So if you hear the term successor trustee thrown around, typically it's the standby person, right? It's the person on deck, right? Who's going to be up at bat if you're a baseball fan. It is the person who is not currently serving as trustee who will become trustee once the current trustee stops serving. So when I stop serving as trustee, I let go of the handle, somebody else picks the handle up. That is the plan that's in place. that trustee reaches into the bucket and distributes the assets according to plan. So other documents that we see are a durable power of attorney for property management and personal affairs. This is a completely different type of document than a living trust. A living trust is a bucket where I put stuff in, and the document has what we call four corners. Imagine a piece of paper with four corners. Everything that happens in the trust, everything that the trustee can do, must be written down. And this is very important. This is why trusts are so long. You can't just have a one-page trust that says, I give my trustee authority to do everything I could do. The way a trust is written is it's fundamentally a contract. The trustee has to have authority, and it must be expressly stated in the trust that the trustee has the authority. With a durable power of attorney, that's an agency document, okay? The living trust is a fiduciary document. The durable power of attorney is what we call an agency document. What's the difference? The agency document, what you say is, whatever I could do while I'm alive, while my heart is beating and I'm alive, whatever I can do, I am designating this other person to act in my place instead, right? Instead of me doing these actions, this other person can do them. They can pick up a registered piece of mail. They can sign my income tax return. They can deal with my IRA because my IRA is not going into my living trust. So very important to consider having that document when you have a living trust, because that covers a different set of circumstances. So that durable power of attorney for property management, very, very important. Advanced Healthcare Directive and HIPAA authorizations. Advanced Healthcare Directive says if I can't make healthcare decisions for me, somebody else makes them. If I'm a goner, pull the plug. HIPAA authorization says if I'm not there physically to pick up medical records or to talk with a medical provider, somebody else can talk to that medical provider. And that can exist even if I have capacity, even if I can make my own medical decisions. And for that reason, we have those in two separate documents. But if you've ever if you've ever tried to get someone else's medical records, you know what a pain in the neck it is, and you definitely want to consider having a HIPAA authorization. Deeds and assignments. So deeds, the way we transfer real estate into a trust, and we cover this on a webinar on our YouTube page, it's by deed. So the way you get your bricks and sticks and dirt, your house, how do you get that into your trust, right? It's a deed. You sign a deed and it's recorded at the recorder's office. So it's a step that you're going to need to take to fully fund your living trust. Now, if your trust isn't funded, you're in probate court. I got to tell you, right? So if I have this bucket, right, this bucket with the handle, and when I put my home into the trust, or if I don't put my home into the trust and then I die, my trustee's holding on to an empty bucket. There's nothing in there. So my trustee might have to go to court to get that real estate into the trust so the successor trustee, right, the person who serves after me, can handle that asset. So again, a living trust provides privacy, avoidance of probate court, and in many instances, minimization of taxes. So there are some tax benefits, not only for, if you have a larger estate, there's some tax benefits by having a living trust. And even if you have a smaller estate, when those assets are inherited by the person who's inheriting the assets, the inheritor, the beneficiary, sometimes there are inheritance tax laws, or there are state death tax laws, depending on what state you live. So these trusts can be used to minimize taxes. So protection of inheritance from creditors, predators, and divorce. What I'm talking about is if you're leaving property to your kids and you're worried about that future ex-daughter-in-law or that future ex-son-in-law, there is a way that you can protect the kids' inheritance. And we do cover that in other webinars. And that's something that's very, very important to many of our clients, because half of all marriages end in divorce. So it's, if you have two kids, there's a probability there, right? It's something that requires planning. So living trusts, generally speaking, broadly speaking, are better than a probate of a will. So definitely something to consider if you want to stay out of probate court. So again, people use living trusts for estate planning, tax planning, asset protection for assets that are inherited, avoiding probate, providing legacy, a vehicle for managing the assets of a beneficiary. What if you got a minor child and, we have people come in, they say, I have a terminal illness and I'm not going to live to see my child's 18th birthday. It's very sad. And these are just heartbreaking conversations that we have with clients. And if that's you, I really feel bad for you if it's somebody you know. But this is a plan where, if you've got a minor child or maybe someone who can't handle those finances, people use a living trust in order to protect that inheritance from a child. So trusts are at the core of many plans. And basically what we're talking about is peace of mind, right? It's getting your affairs in order. It is adulting, right? Adulting is hard. So if you're looking at doing a living trust for the first time and you're like, man, I got to save for college for kids and I got a mortgage and now I got to, my spouse wants me to get this living trust done. Yeah, it's part of adulting. So welcome to adulthood. So, estate planning attorney's role in crafting a living trust centered estate plan. What does a lawyer do? Like, what do you need a lawyer? Can you just go online? Can you use AI to do this? What are some options? But what does an estate planning attorney or an estate planning lawyer do? And by the way, lawyer and attorney are kind of interchangeable in the United States. A lawyer is someone who lawyers, right? Who gives you legal advice. An attorney is somebody who represents you typically in court. They may represent you in a mediation or arbitration, but typically they're acting on your behalf. So, what we're talking about here is typically somebody who's advising you about how to create a living trust. Now, a successor trustee might hire an attorney to represent that successor trustee in dealing with beneficiaries. So that's where if you're wondering the difference between lawyer and attorney, that's what it is. So again, this living trust is a bucket. It's up with a handle. You put your assets into it, your stocks, your bonds, your mutual funds, your IRAs, your 401ks, your 403bs, TSAs, life insurance, and annuities stay out of your living trust while you're alive. So those are not going in there. And unlike a will that takes effect at death, so a will to be valid, a will is not a valid legal document until the person who wrote the will dies, right? So you'll never see this thing be valid because you'll be dead, right? If you have a will, and that takes effect when you die. A living trust is living. It takes effect while you're alive. So a little bit of a nuance there. And this living trust does keep you out of court and saves you $50,000 or more. If you have $1 million estate, $50,000 or more in probate fees. So for a lot of reasons, a lot of people do living trust to avoid probate. So the initial consultation, and what's going on here is when you meet with your lawyer, you have what we call an initial consultation. This is typically a conversation. It's not, a chat thing going back and forth. It's not an email thread. Typically, it's a conversation because it's really an effective way to communicate two humans talking, whether that's in person or by Zoom or whatever, or Teams. If you use Teams, right? I prefer Zoom. I still can't figure Teams out, or anyway, the video. So understanding your goals, the lawyer carefully listens to your specific needs and goals for your estate. The lawyer will ask you a lot of questions. Okay. What you need to have before this sort of initial consult is data. It's best to have data for the lawyer because the lawyer could spend all of his or her time asking you, what are your assets? What do you have? What do you have there? It's best if you provide that information. Typically, a competent lawyer who knows what they're doing, or a savvy lawyer, as we say, would ask you to fill out a questionnaire. So in our firm, we ask people to fill out a questionnaire, give us that information. Some people are a little nervous. They say, well, I don't want to give you this information because I want to talk to you first. And so that can be sort of an issue. And sometimes we just have a conversation, right, without providing information. But I will tell you, by and large, it is worth your time, right? Because you're going to get more benefit from that initial meeting if you provide the information that the lawyer's asking for, okay? So the lawyer conducts this comprehensive review of assets because estate planning is asset-based. So the type of plan that we do does depend on the nature and extent of your assets. So it's very asset dependent. Obviously, your family information. We're looking at your real estate investments, businesses, and we determine the best way to structure your trust and your overall estate plan. Family dynamics. Oh boy, this is a big one. When I was a younger attorney, I became an attorney at 25. And I kind of thought, it reminds me a little bit of, and the name escapes me, but the Russian author who said, all happy families are the same. All unhappy families are unhappy in their own way. So I will say that if there are family dynamics in your family, they're all different. Every single case is different. The happy families kind of are similar. And if that's you, but the longer I do this, the less happy families come in. And I don't know what it is, but there's always something going on with somebody in the family. Maybe it's a jerk brother, the jerk sister. Maybe it's a child that doesn't get along with another child. Maybe you've got some business partners or whatever it is, but there's always something in there that really requires a sufficient understanding on the part of the lawyer of what the dynamics are. So what is your family situation? We want to ensure that your trust aligns with your wishes and provides for your loved ones, the people that you want to leave your property to. And most people don't leave property to people they don't care about. So that's why I say loved ones. If you happen to have children and love them, they're going to be your beneficiaries. It kind of stands to reason. If you don't have children, it might be other people, it might be causes, it's going to be stuff that you care about. So I would say in terms of time budget, I like to budget an hour. Again, when I was a younger attorney, I could knock it out in 20 minutes because I didn't really understand the nuances. But the lawyers at our firm are very well versed in estate planning, and we have weekly meetings. We meet for an hour and a half as lawyers every Monday at lunchtime, and we go over issues, things that come up, and we talk about it. And we talk about the nuances. So, this may seem when you look at this as a layperson, you may go, well, geez, this is really easy. You just fill out some forms, but not so fast. When you actually start peeling the onion, there are many nuances, and this is why you should be meeting with someone who really knows what they're doing. This is not the purview of a generalist, but definitely people who specialize in this area. So, but again, I would budget about an hour. Sometimes it's an hour and a half. I find that after an hour, most clients their brains are kind of fried because it's very intellectual. It's a conversation. You're burning a lot of brain power, and frankly, a lot of people are just tired after an hour. So, I could do this stuff all day. It's what I've been doing for 30 years, but for many people, you get a little tired. So drafting the estate plan. So you have your consultation, and there might be more than one consultation. It depends. If you have a larger estate, there might be many consultations, right? So if a client comes in with a $50 million estate, it's like, well, there's a lot we may be talking about before we actually draft documents. If a person comes in with a relatively straightforward estate saying, I need an estate plan and will and living trust, there might be a single meeting where we work through all those issues, but it really depends on the type of case. So customized trust document. This is really important. Your lawyer should draft a personalized trust document that reflects your unique circumstances and desires. Now, there are standardized components. So it's a little bit like Legos, right? These are standardized components that are assembled by an expert in a way that is uniquely tailored for your benefit. So many of the pages in in the estate plan, clients want to review them and they say, well, the trustee powers, I want to change that power, this power or that power. That's the no-go area. We're not changing that because those are written in the manner that the legal world accepts as being valid. And once you start messing with those powers, and it deviates from what everyone's used to, that is just going to cause problems, right? In our experience. So there are some things that are personalized, that are very specific to you, and there's a big chunk of that plan that is technical language that is not in every trust, right? A lot of trusts don't have some of those terms, but if we as lawyers feel that or believe that you need those in your estate plan, they're going to be in there. Provisions for incapacity. I would say this is probably the single most overlooked aspect in estate planning. So what are we talking about here? Well, if you set up a living trust and you become incapacitated, you're in a coma, you have stroke, dementia, Parkinson's, Alzheimer's, what is it? And you are not cognitively able. Now, physical disability, totally different, right? If you're physically disabled and mentally there, fine. But if you're cognitively unable to handle your affairs, your trust should say that in the event you become incapacitated or are otherwise not able to serve as trustee, this other person serves as trustee and uses this trust property for your benefit. Sometimes these trusts don't say that, and then we have to go to probate court to fix it. So this would be the homemade trust, a bad form that someone got a hold of, maybe just a bad lawyering. I don't know what it is, but sometimes we end up in court because the trust doesn't cover everything that may happen in your life. And again, this is not like 1 in a million probability. Most people have a period of incapacity before their death. So that is, broadly speaking, we see that in our practice. I see that in the data. Most people stop serving as trustee before they die, right? Then someone else is going to have to step in. And then beneficiary designation. So your trust should clearly state how and when your assets are distributed to your beneficiaries. A mistake we see is they say, I'm going to let my trustee decide how to, which kid gets how much. That's kind of a bad idea, right? So a lot of times people say, we're going to divide assets equally, and the trustee, the successor trustee, right, the person who serves maybe after me. So I have a trust, I have 3 kids. I might say the trustee divides everything equally, but the trustee has the ability to give one asset to one child and another asset to another child. That's different than saying, I'm just going to let my trustee decide how much people get. Okay, so it's very important to be clear in your estate plan. Funding the trust, we talk about that. That's transferring your assets to the trust. Typically your lawyer guides you through the process. Your lawyer can handle some of the, quote, funding of the trust, all of it, none of it. This is something that you should be talking to your lawyer about. If your lawyer doesn't even mention this, that is a red flag that you're probably, need to get some legal advice on funding your trust. So this is transferring assets to the living trust. And then the lawyer typically coordinates with the professionals. So they're going to coordinate with your financial advisor, your accountants, and other professionals as necessary to make sure your trust is adequately funded. So there's a consultation, there's some signing some documents, and there's follow-up work. And that all is an arc of time. And typically it takes a couple of months to get finished on that. Could be longer on funding if your professionals are non-responsive, if they don't return our calls or are kind of slow. And that's why it's good. We talk about this in other webinars to have an A team. So we like to work with people that we've worked with before, frankly, so that it's a better, a better job for the client. Ongoing support. So let's say you do this thing and 5 years later, maybe one of your kids has a kid and you're a grandparent. That's great. Well, I want to leave $50,000 for the grandchild. What do you do? Well, you can amend your trust, right? You can update your trust as your circumstances change. Sometimes trusts need to be updated to stay legally compliant, right? And sometimes laws change. In California, we had a really big law change not that long ago that changed the trustee's duties when, like, if I become incapacitated and somebody is serving as trustee of my trust, that trustee has to do new things that they didn't have to do a couple of years ago. Okay, so that was a change in the law, very important. So we want to make sure and pay attention to those changes in the law, really. So the trustees flag, a lot of times the trustees knows what to do, right? Because it's very important to understand a living trust is bound by the four corners of the document, meaning the trustee only has the ability to do the things that are listed in the document. And this is very important. The trustee must do other things that the trust does not mention. Now, these are found in statute. They may be found in case law. A lot of times they start in case law, and then the legislature kind of catches the law up to the case law. And that was what I mentioned about the trustee having to do something if I become incapacitated. So it's very important to understand if you're a successor trustee, or when you think about appointing a successor trustee, not only does that person have to follow the terms of the trust, they have to follow the case law, statutes, and something called doctrine, which is neither a case law or a statute. It's just kind of what judges say is the rule. You got to follow all that. And if you're a trustee, you're held accountable, even though you don't have actual knowledge of those rules. So that's why it's important to get a lawyer, maybe get an attorney in there to help you if you're a successor trustee. So peace of mind. Involving a lawyer provides you with the confidence, right, that your estate plan is legally sound and reflects your wishes. So it gives you that comfort. And really, that's what you're looking for when setting up an estate plan. So why not choose a savvy estate planning lawyer? I wrote a book about this, Savvy Estate Planning, what you need to know before you hire the right lawyer. I would encourage you to take a look at that, to buy it and read it. And it's in its second edition. And savvy lawyer, what is a savvy lawyer? It's someone who specializes in estate planning law and can help you navigate these complex issues. You may not think you have complex issues. You may think it's simple, but there's no such thing. Again, there's no such thing as a simple estate. And the savvy lawyer can create a customized estate plan that fits your specific needs. And this is different than like generic online forms or cookie cutter lawyers, or you can go online and there's a lot of stuff happening online where they say, well, we're not lawyers. You just tell us what you want and we'll write it up. Well, I don't know what I want. Right. I mean, what you have to be your own, you have to diagnose. It's like kind of going to the pharmacy in Mexico and saying, give me that and that and that. I mean, it may help, but you really need that diagnostic procedure and that instruction and that guidance. And really there's a lot of guidance in our book, Savvy Estate Planning, what you need to know before you hire the right lawyer, as well as, meeting with a lawyer. They can really identify what's important and guide you on that. So very, very important. So protection, your savvy lawyer can help protect your assets and ensure your wishes are carried out. So when those assets go to your loved ones, and again, peace of mind, they provide valuable guidance and support through the estate planning process, not only in creating the documents, not only in setting up the estate plan, but also following up in the months and years and decades, right, after you create your estate plan. When updating their living trust, not reviewing all the documents in the estate plan at least every 5 years. That's just out of the gate. It's a mistake. At least every 5 years. It's best to review them every year. Writing on your living trust to make a change, that is probably one of the worst things you can do. It very well may end up in court. It might not end up in court. I can't say, right? But oftentimes there are a lot of cases about trusts where people have written on the documents, so these do end up in court. Removing pages and swapping them for new ones. A document that has been acknowledged before a notary public, you cannot swap pages out, okay? That is an act by somebody who's been appointed by the state of California to verify that that's an integral document. So you don't, when you amend a trust, you don't take a page out. What you do is you do another document that references the prior document that says, remove that paragraph or add this paragraph. So you do not move, you don't take documents out of a trust. Bad idea. Doing a homemade amendment, we see these a lot. Even on very large estates, people do a homemade amendment. An estate comes to mind with a lot of zeros on it, and there were homemade amendments, and it's just a really bad idea, okay? Because these are very technical documents. Too many amendments. What if you have a trust in 9 amendments? How is anyone going to administer that trust? The legal fees are going to be significantly higher, most likely. How often, how many amendments can you do? 1, it depends. Once you get to like 3, it can be problematic. Penny wise and pound foolish. Don't trip over a $5 bill to pick up a nickel, okay? Invest the money, invest the time in quality legal services to get this nailed down appropriately. If you live in California and own a home, odds are it's worth $1 million, right? Because a lot of homes are just worth $1 million or at least 500,000. That's a lot of money, right? That is a meaningful. That's meaningful to the people that you care about. So it makes sense to make the investment to make sure that your estate plan is properly set up, and not using a qualified lawyer when updating your living trust. So if you're a little nervous about what lawyers are charging, remember, the more a lawyer charges, the faster they are. They know what they're doing, and lawyers as a profession are adopting a whole new suite of technology tools to really cut down on the time that it takes to get things done. So I look back 30 years ago when I started practicing law, and the amount of work our firm does on a per person basis is way beyond what it was 30 years ago. Our productivity is so increased. If I could go back 30 years ago and tell myself, I wouldn't believe it. I mean, think about it. 30 years ago, if you could like show yourself an iPhone, you'd be like, why do I need that? So how to pick the right lawyer for your estate plan. How do you do it? One way is read the book, Savvy Estate Planning. What you need to know before you hire the right lawyer, right? Shameless plug for the book. What are factors? We cover this in the book. Reputation, skill, expertise, general comfort level. This is an important decision. And I don't know about you, but I don't really like hiring people I don't like. I mean, you don't have to like your lawyer. I mean, I suppose like a doctor, but still, I mean, general, because there's a comfort level there, because we typically talk about very personal things. It's all confidential. It's protected by the attorney-client privilege. But I think there has to be a comfort level, just realistically. California does have a certified specialist program. Many of our lawyers in our firm either have an LLM, which is an advanced degree in taxation or estate planning, or are certified specialists, or are working toward their certified specialist designation. So California has a special designation. You have to be in practice for, I think it's 10 years, and then take another bar exam and then be peer reviewed. And then you're a certified specialist, which I am. And find a lawyer, if you're in California, California's got the certified specialist program. If you're not in California, and by the way, we do have attorneys licensed in other states. So if you're not necessarily in California, we still may be able to help you. Lawyers who are focused on a particular area of practice, so somebody who holds themselves out as being an estate planning attorney is better than someone who holds himself out as being a divorce attorney, okay? I would say that the people who hold themselves out, broadly speaking, are going to have more experience, more training, more education versus someone who's a generalist or a specialist in a different field. So again, I would find a lawyer focused in this area. You can ask another lawyer. Lawyers are a great source of referrals because they know who they oftentimes know who the good and bad lawyers are, or your CPA or financial advisor. I would say those are the 3 people, the 3 professions to speak with, or go to CunninghamLegal.com if you're not represented and looking for representation. So signs a lawyer knows what they're doing. They discuss with you, right? Protecting inheritances from creditors, predators, and divorce. Use of a trust protector. We cover this in other webinars. Ask about the wealth of the person inheriting from you. Why is that relevant? If you leave $1 million to someone with a $100 million estate or a $10 million estate, you're just throwing it on the pile. That million that you leave to them, if they don't blow it, it's 45% tax after 2025, right? So there are some things you can do so that it's excluded from that person's estate. Funding your living trust. If they don't even mention the importance of funding your living trust, bad sign. Special treatment and income tax planning for IRAs and non-qualified annuities. Very important. So IRAs, we cover this in other webinars. Very special treatment. If the attorney just kind of has a blank look, it's a bad sign. Preservation of Prop 13 taxes in California. It's very hard to do that, but there are ways you can mess it up. And typically this comes up with married couples. So if you have a trust that when one spouse dies, sets up a trust for the surviving spouse, if you add the kids as beneficiaries, it's very important. Oftentimes that will trigger a reassessment. A lot of attorneys don't know this. So, and this does come up quite frequently since passage of Prop 19. Working with your other advisors or your A team. So if they don't even talk about work, if they don't even ask, do you have a CPA or who's your CPA? They don't even ask for your financial advisor. I think that's a red flag, right? We ask for this stuff because we want to know, because we may need to reach out to them to finish your estate plan. So signs a lawyer may not be around when you need them. They are truly a solo practitioner. It's a one-man or one-woman show, right? They don't provide trust administration services. So we see this with some attorneys. They say, oh, I do planning, but if you die, I don't help you, right? So they're not going to be there when your family needs, if something happens to you and you're administering the trust, they're not going to be around. So they make you record your own deed. This is kind of an interesting one. We have a deed service. They're electronic recording now in California, but sometimes people say, okay, here's your deed. Now go down to Norwalk and file that deed in LA County. And I can tell you, if you've ever tried to do that, I don't even think there's a front door in that place. I think people get to work underground or something, or by helicopter. I don't think you can go into the recorder's office in Norwalk in LA County. So a little bit harder, a little bit different in smaller counties. Nobody answers the phone when you call. Well, that's, I'm of an age, and so is my wife. Something wasn't working on her iPhone, her Apple, and she goes, I'm going to call Apple. And I said, good luck. So nobody answers the phone when you call. We still answer the phone in our firm. They don't have a physical staffed office. We have 6 staffed physical offices. They don't provide services of a notary public at signing, which we do. If one of our notaries isn't available, we arrange for a notary to be there. And they don't stay in their lane. They're trying to be all things to all people. We definitely stay in our lane at Cunningham Legal. We're basically representing the mass affluent people, business owners, and those are our clients. So getting an estate plan that is right for you. Step 1. So you're going to do an estate plan. And I know this is a long format, a little bit longer format. Getting an estate plan that's right for you. Step 1, prepare for the meeting, gather the information, meet with the lawyer, complete your client questionnaire. So if you made an appointment with our firm, or you're going to meet with our firm, it is very important that we have this information. Now, some people, like my dad, he has his assets on a spreadsheet. And so if you're the one who keeps your assets on a spreadsheet, great. Just send us a spreadsheet, right? But there are a few pages on that questionnaire where we need family information. And please find your previous estate planning documents if you have any. This is very important. When you amend a trust or restate a trust, it has to be amended or restated in the manner provided in your trust. That is a California law, so it's very important to see that trust. Withholding this information from your lawyer will increase fees, okay? It's just a fact. If you don't give this information when the lawyer asks for it, they're just going to ask for it again. They're not going to do the plan without this information. The lawyer prepares the documents. So some firms send drafts to the clients. Some clients say, I don't want a bunch of homework. Others don't. That's just a choice. We tend to send drafts to our clients unless they say, please don't send them. But we generally send them to our clients. Multiple drafts, editing, boilerplate, and too many meetings increase fees. So what do I mean by boilerplate? Boilerplate are these wonderfully crafted, widely accepted terms that if you look one trust to another, one firm to another, they're the same, like maybe down to the word. They're going to be the same, right? If you start tinkering with that, it's going to run up fees. Multiple drafts, like, well, I can't decide, or I've changed this, or I want to do that. And step 3 is signing documents. Typically, this is done in the lawyer's office. And please keep your appointment. If you don't keep your appointment, the fees go up. And California notaries can't do remote online notarization yet. The legislature has said by 2030, they will be able to. We do not yet have remote online notarization. Other states do. It is theoretically possible to have a Virginia notary notarize your California living trust with the notary in Virginia and you in California, but that makes every lawyer who knows what they're doing really nervous. I got to tell you, it makes lawyers nervous. So it's probably okay, but it still makes us nervous. And again, with that 100% personal liability, we're really careful. How to best prepare before the meeting with the lawyer. Educate yourself. If you go to our YouTube, you might be watching this on YouTube, but we're doing this live. We have over 200 videos in this format of education, right? It's free. This is just out there for the world. Subscribe to our YouTube channel and you click the bell, you'll get alerted by Savvy Estate Planning, what you need to know before you hire a right lawyer, right? That's a really good way because we cover a lot of concepts. We cover a lot of just things that are good to know before you go to the lawyer. This is very important before you go to the lawyer, and be prepared to discuss key decisions. You know, who will oversee you, right? If you become incapacitated, who's going to take care of you? Who's going to take care of your stuff? Who gets it, right? Think about this before you go to the lawyer, right? Because the lawyer's going to ask you. I don't care what lawyer you go to do estate planning. They're going to ask the same question. They're going to ask these questions, right? And please give information when asked. The information provided to a lawyer is maintained in confidence. Very important to understand. If you use a non-lawyer, that is not privilege. So communications with a lawyer are protected by attorney-client privilege. If you do not use a lawyer, you are not protected by attorney-client privilege. And on that happy note, we will end with our office locations in Northern and Southern California, the Golden Gate Bridge and palm trees. Subscribe to our YouTube page. If you love our webinars, please go to Google and give us a favorable review. We love favorable reviews. I will be on a hiatus for 3 weeks, and Tasha is going to do my law partner, Tasha, is going to do second marriages and living trust, blended families and their unique challenges. So this is a good one. So think of Brady Bunch. That's what Tasha's going to be talking about. So we'll open it up for questions. If you're watching this on YouTube, please continue watching, because magically another video, if you've made it this far, another video will roll up right after this one. Thanks for watching.